The assizes and several indictments ready for trial. This restriction forces a sequential process that stalls the progress of cases, extends pre-trial detention, and further crowds the docket. It is therefore our considered view that legislative reforms in this area is long overdue. The time has come for our lawmakers to visit this statutory provision for our one jury trial at a time in order to enhance judicial efficiency while maintaining the sanctity of trial by jury. Trial by jury, as we all are aware, is a constitutional requirement and remains one of the most sacrosanct tenets of our democracy that must be upheld at all times. However, we propose the holding of more than one jury trial at a time for the singular purpose of addressing the huge dockets of our courts. Every term of our court, a pool of individuals is submitted to the Jury Management Office of the Judiciary for jury service. Once selected, these individuals work with the court during trial to hear evidence and return verdict based on the weight thereof. As we commence this term of court, it is our expectation that individuals selected for jury service will devote their time and energy and commit themselves to upholding truth and fairness as they consider the evidence in each case presented to them. Because the jury is a very important factor in our justice system. Individuals who come to serve in this regard must be conscious of the fact that the image of the judiciary also depends on the reasonableness and soundness of the verdict they return in every case. If you come to jury service because you have interest in a case before the court, you are in the wrong place. Because when we find you out, we will apply the appropriate legal sanctions against you. We, however, thank all of you honorable citizens who have come forward to serve your country as jurors. Posterity will be kind to you once you do the right thing. The courts are increasingly inundated with pre-trial motions. Motions to dismiss, motion to quash, motion for separate trials, motion to amend indictment, motions for discovery, etc. All of which must be resolved prior to the commencement of trial. While the right to file motions is constitutionally protected, the sheer volume and substance consumes significant judicial time and resources. In many instances, the determination of these motions spans several days or weeks, thereby delaying the actual commencement of trial and extending the term beyond reasonable limits. Accordingly, counsels are admonished to exercise discretion and good faith in the filing of pre-trial motions, ensuring that they are grounded in law and not merely employed as tactics of delay. The court will not hesitate to institute appropriate judicial sanctions against lawyers who are found to be engaged in acts that are inimical to smooth operation of the court, especially as regards the management of case docket and time. The court cannot ignore the dire condition of pretrial detainees and the overcrowded state of the Monrovia Central Prison. The majority of inmates presently detained are present awaiting trial, many for months, some for years. This situation presents not only a human rights concern, but also a threat to public confidence in our justice system. The law mandates that every accused person is presumed innocent until proven guilty, and that presumption loses meaning when liberty is indefinitely withheld without adjudication. We therefore urge prosecution, the public defense, and all criminal justice stakeholders to intensify efforts towards speedy trials, plea bargains where appropriate, and periodic case reviews to reduce the growing population of pretrial detainees. If you fail to act to ensure that only those who belong in prison are actually there, then the court will not hesitate to apply the law to give pretrial detainees the appropriate relief consistent with law. That being said, we hasten to note that the overcrowdedness of the Monrovia Central Prison is also due to the increase in both the population of Monrovia and criminal activities as a result of the increase in population. For example, the population of Monrovia at the time the Monrovia Central Prison was constructed in the 1970s was approximately 100,000, and the most notable criminal activity in Monrovia during this period was robbery, stealing cash and goods from residences, and heinous crimes such as murder, drug abuse, armed robbery, aggravated assault, criminal conveyance of land, etc., were not on the increase until beginning the 1980s and now. On the other hand, as of the 2022 census, the population of Monrovia was 1,761,032, while as of May 2025, the population increased to 1,794,650. Correspondingly, the criminal activities have increased, so much so that drug abuse is on the increase, and the government declared war on drug abuse, has increased pretrial detainees significantly, and other dreadful crimes such as murder, armed robbery, aggravated assault, criminal conveyance of land, arson, etc. Therefore, as we speak, the Monrovia Central Prison that was built in the 1970s for just 375 inmates now has approximately 1,600 inmates, which means the capacity of the prison has increased by more than 400%. Accordingly, we do appeal to the government of Liberia through the Ministry of Justice to take cease with immediate effect the construction and completion of the new Monrovia Central Prison that began under the administration of President Ellen Johnson Sirleaf in Cheesemanburg, Monrovia County, which, according to information available to us, will host approximately 5,000 or more inmates at a time. Our criminal statute provides for the rehabilitation of individuals who have been convicted and sentenced for crimes committed. So, conviction and sentencing is a continuation of the criminal justice system, which is expected to lead to rehabilitation of convicts. When a convict is sentenced, the application of the criminal justice system does not necessarily come to an end. The rehabilitation process of convicts now becomes a responsibility of the state to ensure that the character of offenders is informed in order to prevent future crimes. This process aims to address the root causes of criminal behavior, such as addiction, lack of education, unemployment, or psychological issues. The need, therefore, to refocus on this aspect of the criminal justice system cannot be overemphasized. Hence, the need for the Ministry of Justice to focus a little more on rehabilitation of convicts, which will also lead to an eventual decongestion of the already overcrowded Monrovia Central Prison. The other aspect of the criminal justice system that we would like to highlight is the probation process. As we all know, probation is a non-custodial sentence that allows an offender to remain under supervision in the community instead of serving time in prison. Its main purpose are to rehabilitate through supervision, reintegrate offenders in communities and maintain family cohesion, reduce overcrowding in prison, and give the offender a second chance without incarceration. The reason behind these ideas and efforts is to ensure that prisons are not overcrowded and that only those convicts who are supposed to be in prison are there for the overall safety of society. We again call upon the Ministry of Justice to do all of its means to rejuvenate this program, which we believe will eventually reduce inmates intake and keep the Monrovia Central Prison hygienic and healthy. Equally concerning are the habitual lameness and unpreparedness of some members of the bar in attending court assignments. The timely commencement of court proceedings is a mark of respect. Respect for the bench, for the litigants, and for the sacred process of justice itself. Lawyers must remember that they are officers of the court and owe a dual duty to their clients and to the court. When counsel fails to appear on time or come prepared for trial, they not only injure their client's cause, but also obstruct the administration of justice. Every litigant deserves adequate legal representation, and when you fail as a lawyer to provide quality service to your client, the court is obliged to call you to order, consistent with the appropriate provisions of the Code of Moral and Professional Ethics for Lawyers. Henceforth, the court shall insist on strict adherence to court schedules, and the appropriate sanctions shall be applied for unjustified tardiness or neglect of professional duty. It is a well-known fact that there will be no wholesome functioning court without effective and efficient clerical and ministerial staff. Your contribution to the overall success of the court, to the work of the court, cannot be overemphasized. This is why we encourage you to always put your best foot forward in every assignment you are given to execute. Whatever you are required to do as a court officer, do it to the best of your ability. It has come to our attention that you have a major role to play in the market image problem being faced by the judiciary. We urge you to do your work and do it diligently. Come to work on time. Take your assignments and duties and execute them fully without asking for extra reward in return. Stop charging lawyers and party litigants extra fees for services you are being paid to perform. This is taking a toll on the image of the judiciary. We therefore encourage lawyers and party litigants to file complaints against clerical staff and ministerial officers who are making demands or asking to be paid extra fees for jobs they are already being paid by the judiciary to perform. You have to file the complaints against this unwholesome conduct so that we all join the fight in restoring the image of the judiciary. Finally, we reaffirm our unwavering commitment to the vision and leadership of His Honor, the Chief Justice of the Supreme Court of Liberia, Nyami Kokebesisini, whose administration continues to champion the enhancement of the rule of law, the integrity of the judiciary, and the eradication of ethical conduct in our ranks. As judges and judicial officers, we must embody the highest standards of ethics and impartiality. The robe we wear is not a symbol of privilege, but of humility and service. We must ensure that our actions, both on and off the bench, reflect honor upon the judiciary and inspire public confidence in its independence and fairness. In this way, we reassure public confidence and trust and re-establish ourselves as the moral compass of society, whereby our people will rely and trust our ability to dispense justice without fear or favor. As judges, we should not misunderstand our calling to the bench and see ourselves as being above reproach. We must demonstrate the highest standards of truth-telling, trustworthiness, impartiality, diligence, hard work, integrity, respect for the rule of law. This is the only way by which we can earn the respect and trust of the public. We must demonstrate that we deserve their trust by exhibiting these virtues in an exceptional way. If we judges cannot live by good examples, we should not expect anything different from those who appear before us. As we continue this, as we commence this November 8, 2025 term of court, let us do so with renewed commitment to efficiency, effectiveness, discipline, professionalism, and integrity. Let us remember that the cause of justice is greater than any one of us, and that history will judge us not by the cases we heard, but by the fairness and courage with which we decided them. May God grant us wisdom, patience, and strength to discharge our duties faithfully. With this, I now declare the November 8, 2025 term of criminal assignments A, B, C, and D open for the transaction of business, and it is hereby so ordered.
They are protocol by His Honor, Usman and Fekara. May it please Your Honors. You clearly talk about the issue of challenges in the system. We agree with you that in order for our system to work, there are prevailing challenges. And those challenges, the Ministry of Justice will work with the court to ensure that some of those things will be minimized. Also, during your charge, we talk about restriction in respect of jury trial. Yes, it is a problem. It's a system problem which is laid out both in our Constitution and that of the statute. That is beyond the control of the Ministry of Justice and even the court system. Because firstly, the issue of jury trial is embedded in our Constitution. In order for us to have that corrected, it means we have to go for referendum. So we hope that all of the stakeholders will work on that to ensure that they be done and properly so that we can have speedy trial. Your Honor, you talk about the issue of motions, pre-trial motions. We agree with it. Some of the motions sometimes not just necessary. But again, it has a conviction in the law that says that people must be able to exercise their rights. And so, in most instances, the defense will always take advantage to ensure that all of the pre-trial motions are exhausted. So again, as we rightfully said, we talk about the public defense, the prosecution, and the court. We need to look at that and make it better. We talk about pre-trial detainees. As we all know the system how it works. Sometimes it's not an issue of justification, but the way our system works, it makes it difficult. Because, like for example, you sit as a magistrate, and a complaint is brought before you. Sometimes it's not the fault of the magistrate, probably giving the person the way the person performs, or perpetrated the act in the community, probably angry. For example, if he goes back to the society, if the magistrate gives him 13.5, he goes back into society. People will feel that he arises about with them, and as a result, the issue of more violence becomes about. So again, we all have to sit and look, and that's the reason why we have this fast track code, and we hope we can make it more functional. You already talked about the issue of the responsibility and the rehabilitation and probation service. I think quite recently the president just ordered the board of parole to take care of some of these things, so as to decongest the prison. But as we speak, we all know that the Ministry of Justice has this probation program. And in fact, some of our prisons where people are, like in Banga, people are there learning other things so as to change things so when they come into society they can become better. So we have some rehabilitation. It's just a matter we have to step it up. On the issue of the probation, yes, we agree that we all can work together. You talk about the punctuality of the lawyer, the duty. The other, we assure you they will work along with our prosecutors to ensure that they be able to properly manage the very person we assignment to, so that at least you will get the results that you want. So we'll cooperate with you in that respect, this term of code, and other times. You talk about the clerical staff. The other, we agree that these people, without them, the code will not move. However, as we rightfully put it in charge, we just need to step out the game a little bit so that people will try to have that confidence in the system. Because if the people see, because like for example, if there's a ministerial code, and somebody who is so much disheartened or maybe probably affected by somebody's action, and first encounter will be the court officers. And if the officers behave in a manner that is not professional, it discourages me. So we agree with you that they need to step out their game. Again, you talk about the issue of the judges. We agree because we appear before you. And if the outcome of what you tell us, that is the parties, it must be clear and to the point in terms of being impartial, so that the justice that all of us are looking for. And I've always told people, though we are still lawyers, but we have other private prosecutors who represent. Like for example, if a crime took place in the bank, that bank, the money that's in the bank is not for the bank itself, it's for Liberian citizens. So in as much as we are still lawyers, we are also protecting the right of other people. Because there are people that are giving money that place in the bank, and you got one individual who will just take the money and misapply it. So it's the Liberian people that we represent. So we hope that we all can be able to do it better for the good of our country. Having said that, you are welcome. The Minister of Justice and the Attorney General asked that we welcome you and we cooperate with you with the strength and show that whenever you need Minister of Justice, that call to us will be available. Thank you so much. I submit.
It is interesting when the Minister of Justice says that most of the time the overcrowdedness of the prison is caused by the fact that when we exercise 18.2, the Ministry of Justice resists.
Yes.
And the judges are very reluctant to rule accordingly. The second thing is, for the past 1 year plus, public defenders have been absent from the ministerial courts. We have raised the issue, even though the new Chief Justice has assured us that we will go back to the ministerial court. Because the ministerial courts commit more people to prison than the circuit court. Your Honor, again, as we come for this November term, we are willing to cooperate with the Ministry of Justice and the court to decongest the prison. I mean, I'm glad that you noticed that indeed the prisons are overcrowded. Not only in Monrovia County, but throughout the country. We also want to inform you, Your Honors, that the public defenders are up to the task. We are up to the task, but we have few challenges. And as we live, there will be challenges, but please try to help us reduce our challenges. Thank you so much.
For the splendid briefing that you made today. You really have said it again that judicial reform is a must. And we want to have our voice as the trial judges to say that this reform should also include the magisterial courts to the extent by which our jurisdiction can be expanded to help you in some of the difficulties that you are just expressed. So on behalf of trial judges, we want to say welcome to the story of to all of you our judges, and we wish you a great time in this program. Thank you, Your Honor.
Okay, we are on this session of the movie of the water. I hope we will call on the sheriff to go out there and start